Details about last week's town council meeting on this episode of Barnstable Today. It's Monday, April 7th, 2014. I'm Sarah Mann. Town Council votes against a petition that called for the town's withdrawal from the Cape Cod Commission. The binding measure would have placed the question on the ballot in November. Barnstable resident Ron Beatty urged the council to support the petition prior to the vote.
As a rationale, such a proposed petition to the Barnstable Town Council is solidly grounded upon the First Amendment to the United States Constitution and, quote, the right of the people to petition the government for a redress of grievances, unquote. Furthermore, funding for the Cape Cod Commission is based upon population, with the town of Barnstable paying a substantially larger share of the financial burden for the Cape Cod Commission than any other Cape Cod town. However, through their appointed and non-elected representatives, each of the Cape municipalities has equal voting power on the Cape Cod Commission. It is seriously contended that the town of Barnstable is presently both underrepresented on the Cape Cod Commission and overcharged for the services that it receives from the CCC. The chief issue is equal representation as defined under the 14th Amendment to the United States Constitution. At a minimum, since the town of Barnstable has the largest population and is charged the most amount of money to support the Cape Cod Commission, then fairness dictates that the town of Barnstable should possess a weighted vote in proportion to its larger population, similar to what it now rightfully enjoys on the County Assembly of Delegates. Moreover, since the CCC possesses concentrated regulatory and political power on a Cape-wide basis, then respective town representatives to the Cape Cod Commission ought to be democratically elected by the voters of each town rather than appointed by municipal officials.
Town Attorney Ruth Weil also addressed the council. She said the petition was flawed.
As noted in the submitted petition, Section 8-7B of the Charter requires the Town Council to hold a public hearing on a petition submitted by at least 150 voters and then act by taking a vote on the quote-unquote merits of the petition. To place the group petition in a historical context, the first question that was presented to the Town Council under Section 8-7B involved a petition that asked the Council to adopt an ordinance that would independently regulate abortions throughout the town of Barnstable. Unlike the initiative petition found in 8-1 of the Charter, which requires the town attorney to determine whether proposed measures could be lawfully passed by the Council, the group petition does not provide any such legal pre-screening. Instead, as noted above, the Charter simply requires the Town Council to hold a public hearing and then act on the merits of the petition as presented by the petitioners. If there is no affirmative vote that the petition has merit, that ends the matter. After an affirmative vote, the Council can decide what, if any, action it deems appropriate to take. In light of the requirements of the open meeting law, the action on an affirmative vote would most likely have to appear on a future council agenda. So that gives the parameters of dealing with the merits of the petition. In terms of the petition before you, the petitioners are requesting a binding local public policy question be placed before the voters at the next town election, state election, or special election, whichever occurs first. As a starting point, and I became much more aware of how items get on a ballot than I ever was aware before in doing the research for this matter, there are very limited ways that matters get before the ballot. The ballot for questions is as strictly regulated as the ballot for placing candidates on election ballots. A binding question can only be placed on a ballot when specifically authorized either by statute, special act, or charter. For example, items that you're familiar with, Proposition 2.5 is a ballot question which is placed by the Town Council on a ballot and is prescribed by the statute. In fact, under the statute, even the language that must be put on the ballot is contained in the Proposition 2.5 statute. The Community Preservation Act was an acceptance by a ballot vote the language of which was prescribed. When we accept certain special legislation, an issue that is dear to our hearts this winter, plowing private roads, that was an exception statute which also had required a ballot question under the statute. There are no state statutes that apply to the matter before the council in this petition. So our next step is to look at the charter. And is there any charter provision that allows the placing of an item on a binding question on a ballot? And the only one that's available to accomplish that goal is under Section 8-1. And this is the procedure where a citizen asks the town to place a binding question before the electorate. The first step is to collect signatures of 10% of the voters in the town, and that would be approximately 3,300 signatures. That has not occurred in this case. The town clerk has certified, it's my understanding, 180 signatures. So for a binding question, that doesn't meet the initial threshold. Even beyond that, if there were the requisite number of signatures, the next step is to refer the matter to the town attorney, as I alluded to before. And the town attorney has to determine whether it meets the criteria for an initiative petition. I respectfully assert that I don't think that this petition would even meet the criteria for an initiative petition, even if they had the correct number of votes. Finally, I've spoken to the Secretary of State's office, and even if it had been a proper binding local initiative petition, it would not make the state ballot. It is not the type of item that would go on the state ballot. So, in my opinion, this petition is legally defective and flawed. And to recap, after you hear testimony at the public hearing, the council has to vote on the merits of the petition that is before you.
After a lengthy public comment period, councilors ultimately voted unanimously against the petition. The capital budget for FY15 took up much of last week's town council meeting. Presentations and public hearings began with the Water Supply Enterprise Fund, Water Pollution Control Enterprise Fund, Solid Waste Enterprise Fund, and the schools. Each of the items were debated thoroughly. Superintendent of Schools Dr. Mary Schakowsky spoke about funding requests for the school system.
As I indicated, we have a total of 8 projects, and I'd like to first talk about our first project, which is the Barnstable Early Learning Center. The scope of this project, it's our first priority for a proposed Barnstable Early Learning Center, which is the first phase of a 3-year plan to address space needs in our pre-K to 3 programs. This request will fund the construction of a 7,500 square foot 6-classroom preschool center located at the Hyannis West campus. Justification for this program. Barnstable Public Schools has closed 5 schools over the last 10 years. The reduction in schools, a result of declining enrollment, has resulted in overcrowding and students being educated in inappropriate spaces in our elementary schools. Currently, 3 of our elementary schools, BWB, Centerville, and Hyannis West, house 5 portable trailers, some of which have been in place for over 40 years. Classroom instruction, including technology and special education, is taking place in these inadequate spaces with mold, poor ventilation, and leaking windows. We are grateful to the Town Council last year for appropriating $125,000 from the Capital Trust Fund to remove these portable trailers and conduct an alternate space assessment study. Over the last 3 years, we have seen an upsurge in our elementary enrollment in spaces that are already on stages and in locker rooms, thus necessitating an additional classroom at both West Villages and next year the additional space for 2 classrooms at Centerville Elementary School. So why do we need a new early learning center? First and foremost, our integrated preschool program is not a nice-to-have program. It's mandated as we are required to provide educational services beginning at 2.9 years of age to kindergarten for identified students with disabilities. Increased needs for our students with disabilities, as well as the changing demographics of our students, continues to be a priority in the district.
Ultimately, 9 counselors voted in favor of the school system's capital improvement plan. Counselors Cushing and Norman voted against the plan, and Town Council Vice President Ann Kennedy abstained. All other items presented to Town Council were approved. Town Council will continue working on the fiscal 15 capital improvement plan at its next meeting, April 17th. Be sure to tune in to our hour-long news program, Barnstable This Morning, weekdays at 7 a.m. On tomorrow's show, we'll chat with Police Chief Paul McDonald, State Senator Dan Wolf, and have all the news and information you need. For Barnstable Today, I'm Sarah Mannel.